court has already begun releasing decisions on the cases it heard this term. And in the coming month, we will expect a flurry of major decisions that could upend every aspect of American life. We are fortunate to have with us today some of the foremost constitutional law experts and court analysts in the country to break down exactly what is at stake in this term and how progressives can respond to the extreme right-wing supermajority on the court. Historically, the Supreme Court has intended to serve as a key element in maintaining checks and balances of American constitutional governance. At his confirmation hearing nearly 20 years ago, Chief Justice John Roberts claimed that it is not the role of the courts to be policymakers, but to interpret the law. Reality has been far different from that. In recent years, the 6-3 right-wing majority on this court has not only upended decades of precedents, but has actively sought to craft policies and laws that unequivocally benefit their partisan allies and corporate interests, consistently at the expense of our democracy, at the expense of workers, consumers, and the environment. As the court has taken a more actively ideological role, it is little surprise that the public no longer trusts the institution to protect our rights and freedoms. Data released just this month shows that only 34% of Americans approve of the Supreme Court, a historic low. And the public backlash has not mattered to this right-wing court. Nothing would suggest that they have been chastened. This term, the Supreme Court is poised to continue putting extreme right-wing policy objectives ahead of established precedent and principled legal reasoning. Just last week, the court continued its crusade against voting rights in Alexander v. South Carolina Conference of the NAACP. Justice Alito wrote for the majority, overturning established precedent and overturning established precedent to reverse the way courts reviewed allegations of racial gerrymandering. The court's decision will likely make it nearly impossible to successfully challenge gerrymandering maps on the basis of race in the future, further eroding the Voting Rights Act and the rights of Black Americans. But this is just the tip of the spear for what may come this term, with a court willing to substitute their political ideology and policy preferences over longstanding precedent and the rule of law. A number of cases addressing administrative law, Loper, Bright, and Relentless, Jarchese, Corner Post, Ohio v. EPA, could rip away vital restraints on corporate power in this country and kneecap the ability for federal agencies to protect workers, consumers, and the environment from corporate malfeasance. Another set of cases, Alliance for Hippocratic Medicine v. FDA and Idaho v. US, reflect the far right's push to end women's rights to an abortion across the country and undermine the federal government's ability to step in to protect the right to essential reproductive health care and bodily autonomy. And of course, the January 6th cases, Fisher v. US and Trump v. US, will have resounding repercussions for the American democratic experiment. On this last case, Supreme Court's actions throughout, first refusing to hear the case when special prosecutor asked for it to be considered last year, and now unnecessarily delaying a ruling on Donald Trump's absurd argument the president should be held immune from all legal recourse. All of these decisions by the court are aimed at protecting Donald Trump from accountability for his actions related to the insurrection on January 6th. And reporting, both old and new, has confirmed that what the American people have long believed. Far from being impartial umpires calling balls and strikes, these right-wing justices are partisan political actors. As a result of their actions on their rulings, the court is facing an ethics crisis. And Congress must step in to enact bold, robust reforms to restore accountability to a shameless and power-hungry judiciary. There are popular solutions at the ready. Nearly 2/3 of Americans, 64%, support 18-year term limits for justices. 3 in 4 Americans, 74%, support Congress enacting a binding code of ethics on the court. And Congress needs to do more to stave off this relentless right-wing judicial power grab. They must consider limiting nationwide injunctions, preventing judge shopping, mandating transparency for the justices, and promoting the ability to hold corporate actors accountable by codifying Chevron deference. And with that, I'm thrilled about the conversation we're hosting today. with the opportunity to hear from some of the leading court analysts and constitutional experts in the country. Today, we have Professors Carolyn Fredrickson, Professor Kate Shaw, and Professor Steve Vladeck to get their take on the stakes for the country with the upcoming court decisions, how these cases fit into a larger right-wing movement to consolidate power and control in the courts, and how this court can itself be reined in. And with that, I will turn it over to our moderator and my colleague, Senior Director for Courts and Legal Policy at CAP, Devon Ombres. Devon?
Thank you, Navin, for that necessary context and introduction. And thank you to those of us who have tuned in to join us for this important conversation about the 2023 Supreme Court term. A quick reminder that we will set aside some time at the end for questions from the audience, so please use the Q&A function to submit questions throughout. And most of all, thank you to our esteemed panelists for joining us from across the world and sharing your wealth of knowledge with us. Joining us today, Professor Caroline Fredrickson, the Distinguished Visiting Professor from Practice at Georgetown Law Center and Senior Fellow at the Brennan Center for Justice, Kate Shaw, Professor of Law at Carey Law School, and Steve Vladeck, Professor of Law at the University of Texas School of Law. There's a lot of ground to cover today, so I'd like to jump right into the conversation. And given the news of the day, I think we need to start with the January 6th and presidential immunity cases that haven't been decided yet. Because there's been a large push for Justice Alito to recuse himself from those cases, given the upside-down flag flying in front of his Virginia home and the Appeal to Heaven flag flying outside of his New Jersey beach home, both of which have been co-opted as symbols by January 6th insurrectionists. A few hours ago, Justice Alito refused the Senate Judiciary Committee's request for recusal, saying that it was his wife who raised the flags, and anybody who is reasonable would be able to say that there was no impartiality there. But it's interesting because it feels like Justice Alito, when saying that he is required not to recuse, is both relying on this non-binding code of ethics that the Supreme Court adopted back in November, and also showing contempt for it by saying that anybody who thinks otherwise is not correct in their assessment of impartiality. And he also seems to balk at the very concept of checks and balances, whereby Congress can actually conduct any degree of oversight on this court. I would just love to get your brief initial reactions before we get discussing the merits of all of these cases that are coming along. And if I could start with you, Professor Shaw.
Sure thing. Happy to be here and happy to jump in. The news gods have obviously served us some breaking news to kind of digest here, and I'm really looking forward to hearing what my co-panelists think about this latest development. I mean, I'll say a couple of things. One, it was striking that Justice Alito personally responded to a letter addressed to the Chief Justice. And so it was Senators Durbin and Whitehouse actually asked for a response from John Roberts, but Justice Alito essentially elbowed Roberts out of the way and said, actually, I'm the guy to talk to, and I'm telling you, I'm not recusing. And exactly as you suggested, Devon, he sort of turned around the calls for his recusal to suggest that rather than, motivated by good faith, it is those calling for his recusal, I'm just going to read a quote from his letter here, who are motivated by political or ideological considerations or a desire to affect the outcome of Supreme Court cases. That is essentially the characterization that his letter offers to those calling for his recusal. A couple things, the letter, for those who haven't read it, the TLDR really is, it was essentially Mrs. Alito, full stop. Justice Alito wasn't aware of the flags being flown in one case, at least. He sought to intercede to prevail upon her to lower the flag. She refused to do so. So really, this was all about Mrs. Alito. But there's also, I think, in the letter, essentially a refutation of the claim that the semiotics of the flags are what they are. And I just don't find that remotely plausible. So there's a suggestion, I didn't know that these flags had become associated with MAGA or the Stop the Steal movement. That's explicit in the letter. And I just find that, again, not a credible claim. At the time these flags were raised, they were understood by at least a lot of people, not by everyone, but certainly by those who would, I think, display the flags, that they had a meaning, and it was both, I think, a political in some ways and critically a legal meaning, right? So the political meaning, I would say, is that, that Donald Trump was the rightful winner of the 2020 election. The election was stolen. I think that's sort of a political claim, but it's also a claim with some, legal implications, because it does, I think, bear really directly on two of the cases that you mentioned, Devon, the Fisher January 6th case and the January 6th case involving Donald Trump himself, which is, it's not, I don't think, crazy to presume that individuals, with sympathy for the sentiments, I think, communicated by the two flags might have a view about the characterizations that prosecutors have offered around conduct on and before and surrounding January 6th. So I think that the two are very tightly linked, and the suggestions that, in fact, that, the two have nothing to say to each other, nothing to do with each other, the flags and their sort of contested meaning on the one hand, these January 6th cases prosecuting individuals for their involvement in the violent attack on the Capitol and the insurrection. I think, again, those aren't credible claims. So those are some of my initial reactions, having literally just read the letter, but I'm eager to hear what the others on the panel think.
Yeah. Thank you, Professor Shaw. I really appreciate that. And just piggybacking off of that, and you mentioned the Anderson case and the presidential immunity case being wildly divergent. Professor Vladeck, I wonder if you could comment on how those are so different and how this indication of impartiality plays into the way the court is treating both of these cases.
Sure. I mean, I think a couple of things are true. I mean, I think, first of all, no one really has much doubt where Justice Alito is going to come down in the January 6th immunity case, or I think in Fisher. And I think that was true long before Jodi Kantor's first reporting on the upside down flag, hit the New York Times, gosh, almost 2 weeks ago now. And Devon, I think the second point, and this is where I guess I'm going to be a bit of a curmudgeon, is that I think the more that we view this through the lens of recusal, the more we're actually letting Alito off the hook, because I think there actually are certainly at least non-frivolous arguments for why he doesn't have to recuse in either Fisher or the Trump immunity case. Even though those arguments depend upon him completely throwing his wife under the bus, it's not entirely beyond the realm of possibility that things happen the way that he claims they happen. The problem is that if we have a fight about recusal standards, we miss the larger question, which is whether Justice Alito is engaging in good behavior within the meaning of Article 3, Section 1. And it seems like we ought to get much more comfortable talking about good behavior as not being limited to the justice's behavior in the specific cases the court is hearing. Right? If a justice were to go out and publicly give a series of speeches at, I don't know, white supremacist rallies or anti-Semitic demonstrations, or, go on the other extreme, I think that would raise serious questions about their behavior, even if there was absolutely no connection to any ongoing litigation before the Supreme Court. And so I worry that, the more we make this about should he recuse or shouldn't he, the more that we're actually letting him off the hook. When, to me, the real problem is how completely unconciliatory and unapologetic he has been about this episode. I mean, maybe it was all Martha Ann. Maybe he really did try to convince her to take the flag down. But that seems to be almost conceding that he understands why it's a problem that this flag was flying outside of his house. And so I guess my reaction is, and this is a sort of a long-term problem for me, I think we spend too much time analyzing the court through the lens of individual justices' behaviors in individual cases, and not enough time talking about the justices sort of more holistically. And, do I think Alito owed more of an apology for all of this? Absolutely. Do I have to believe that he has to recuse in order to believe that? No. And we ought to be able to believe both of those things at the same time.
That is reasonable enough. So to my mind, just taking this in the context of things, in the two cases, again, just Anderson and Trump, I think it's interesting to look at the way Alito is analyzing things, in the way that the plain meaning of the 14th Amendment, at least to my mind, was completely gotten wrong in the Anderson case. And now in the Trump presidential immunity case, we have the folks like Justice Alito putting presidential immunity, which is found nowhere in the Constitution, into play. So Professor Fredrickson, could you comment on how we can rationalize what's going on with the court in these cases?
Oh, well, I'm going to put my cynical hat on now, I'm afraid. But first, I want to thank you, Devon, for hosting this, and to my fellow panelists who I have to say I listen to regularly on their podcasts, and so most of what I say is just plagiarized from what they've already said. But I'm influenced by only the best constitutional scholars. But to say, I mean, I think there is disingenuous is such a nice word in this context. You know, and I want to put a flag in this because, or I know we normally say we put a pin in it, but put a flag in it. Because I think the fast and loose way that number of justices, but I think Justice Alito in particular, play with claims of originalism, history, and tradition, and so forth to advance a very, very particular hard right position, I think is something that we really need to account for, as well as, you know, and I completely agree with what Steve had to say about Justice Alito's behavior just being bad. I think the idea that someone with his intellect could come to his own home and see an upside down American flag and not have some questions about what might be going on, or perhaps a flag that says an appeal to heaven, it might be at least puzzled if he doesn't know what it already means, and might bother to actually, you know, go online and do a little research just to ask his wife, what is this all about? You know, and I want to mention just in this context, I know we're going to get to the South Carolina redistricting case, but in that context, Justice Alito, you know, it went in a very extreme way into the factual findings of the trial court in a way that is unseemly, is inappropriate, is not what the role of an appeals court in these kinds of circumstances. And yet here, where he's got a situation of a very strange set of events in his own house, where his wife is flying an American flag upside down, allegedly his wife, he doesn't bother to even check the facts. I mean, I think to say that it makes me have a great deal of cynicism about his motivations, about his use of terminology like originalism, history, tradition, etc., is really to put it mildly. And I think, you know, I think the fact that was, you know, stated at the beginning of this program about the historic lows to which the Supreme Court has fallen, I think, is really has been driven by the actions of justices like Alito, who really show a disdain for the American public, or even for the issue of issues of rule of law, to the extent where, as was already mentioned, he is disdainful of checks and balances, suggesting that we have some kind of extreme separation of powers under our Constitution, which, however, only goes one way, right? No one can check the Supreme Court, but the Supreme Court is fully free to check everybody else. You know, they can check the executive, they can check the Congress, but nobody can tell somehow constitutionally the Supreme Court what to do. And I think it puts us at a position where the Supreme Court is now a branch of government that is falling into disrepute. And as we all know, that the only power of a court is really the power of trust people have in rule of law.
Disrepute and disrepair. I was going to move on to the admin law cases, but Professor Fredrickson, Professor Shaw, you guys both brought up great points about Alexander, so I want to skip over to that just briefly. And Professor Shaw, you said that Justice Alito accuses the people who bring this issue up as being motivated by ideological reasons. And in South Carolina, where he completely upended, he wrote the majority opinion 6-3, upended the way that racial gerrymandering is considered by the court. He said, we must be wary of plaintiffs who seek to transform federal courts into weapons of political warfare that will deliver victories that eluded them in the political arena. So kind of just transitioning, keeping on the Alito topic, but transitioning into the subject matter and the merits. How do we see this judicial hubris translating into opinions, and how is it affecting the actual rights of everyday Americans?
I think that quote that you just read, Devon, from the Alexander case from last week, is an example, I think, both of projection, and also I think of the sort of hubris that I think is a defining characteristic of this court in this moment in time, at least of the 6-3 majority. And right, that's a case where the court basically says, we know better than this trial court that had conducted a careful trial and fact-finding and determined that race did predominate in a constitutionally impermissible way in drawing, a district in the South Carolina congressional map. And the court, I think, did there what I expect it to do in the, Loper, Bright, relentless cases that, and if it's okay, Devon, maybe I'll use this to sort of bridge to those administrative law cases. But I think I expect the court to do something similar, which is essentially assert more power that the court itself possesses, and potentially do that in a way that is contemptuous of kind of other institutional players and entities in our separation of power system. I mean, Caroline was talking a minute ago about the court as viewing itself as sort of standing outside of a system of separated powers. And I think that's exactly right. And I think the separation of powers is always dynamic, and it always, requires negotiation and renegotiation. And there have been moments in time when the balance has gotten really out of whack, where in the Nixon administration, the presidency was largely behaving in an unchecked fashion. In the early New Deal period, the Supreme Court was acting, in a way that sort of was out of whack in terms of a healthy system of separated powers, and institutions responded. And I think the Supreme Court we are in one of those moments with respect to the Supreme Court right now. And I think that is true as to the kind of ethics and conduct of some of the justices, but I also think it's true as to the substantive opinions being rendered by the court. And some of this is predictive, right? We don't know a lot of what the court is going to do, but I think we have a pretty good hunch from their track record and from the questions that they posed at oral argument. And as to, there are a bunch of administrative law cases, but as to Loper, Bright / relentless, the two cases in which the court is being asked to overturn the 40-year-old precedent, Chevron, which is really the most important case in administrative law, if the court proceeds as I think we all, or many of us, expect it to proceed, and it overrules Chevron, it will be essentially saying that this long-standing sort of 40-year-old set of institutional practices and understandings against which administrative agencies have operated for decades, whereby when Congress legislates and leaves gaps or ambiguities in statutes, it is the agencies that get to take the first crack at filling those gaps and ambiguities, and that courts, so long as agencies behave reasonably, should essentially give agencies sort of a position in the driver's seat at interpreting ambiguous provisions in statutes. What the court, I think, may well do here is to essentially oust agencies and assert for itself the power to drive that car. And that I think will mean a couple of things, right? One is it'll disempower agencies. And I think that maybe is especially true when paired with the kind of novel major questions doctrine that the court has deployed with increasing frequency and intensity in recent years to invalidate anything big and significant that an agency seeks to do. But I think that, the court overturning Chevron and replacing it with a regime in which the court is the primary interpreter of statutory ambiguities, and in which anything significant or with a high price tag or, politically or sort of economically important, agencies are presumptively disabled from doing at all. Again, paired with court in the driver's seat and a deeply skeptical majority, skeptical as to agency and maybe even governmental power writ large, I think just means that there will be much less space for agencies to meaningfully regulate in the way that we have all become accustomed to them regulating in ways that are often, invisible, but hugely important to us, touching everything from clean air and water to drug safety and efficacy to, food and consumer product safety, workplace conditions, you name it. And so all of these are the kinds of topics that agencies touch, and where I think the court with these various interventions may be making it significantly more difficult for agencies to meaningfully, regulate in these domains. And I think that will simply mean not just more judicial power, but less meaningful regulation, and more of us, and maybe the more vulnerable among us primarily, being subject to, threats and lack of safety and, environmental protection in ways that have very tangible consequences for ourselves and our families.
Thank you so much. That's incredible. You mentioned judicial humility, judicial hubris. I've been of the understanding that Chevron doctrine is itself a doctrine of judicial humility because it gives the power away to do a coordinate branch of government, whereas major questions and other things are more a doctrine of judicial authority and power. But if Loper, Bright, and Relentless go the way that we think they are, whether they be narrowed to the point of unimportance or completely overrun, Steve, I wonder if you can talk about how that is going to just disrupt the legal system, because you've been writing about nationwide injunctions and the shadow docket and judge shopping for quite some time. I imagine that it is going to just supercharge the way that we see right-wing litigation against agencies attempting to protect the health, safety, and well-being of Americans in just any number of policy areas.
Well, I mean, Devin, I think that's right now. And I think in a Republican administration, we would see the polarity switch. And, I think that's part of the problem is that we haven't sort of talked in organized form yet about one of the real catalysts of the Supreme Court's current term, which is the U.S. Court of Appeals for the Fifth Circuit, which is responsible for 11 of the 55 plus cases on the Supreme Court's docket, which is just a stunning number. But one of the things that happens in a world in which courts can decide for themselves not just what agencies mean, but also which issues are of, quote, vast economic or political significance, unquote, which is the test for a major question. Devin, the reality is that litigants are going to try to bring their cases to the friendliest possible judge they can find. And two things have happened in the last decade that have really, I think, put the turbo boost into this. The first is, as the federal courts have become more polarized, we've had more, I think, for lack of a better word, ideological outliers appointed to the federal courts. We focus on the Supreme Court, but the real impact, I think, has been on the lower courts. President Trump's, most, I think, impactful judicial appointees, I'm going to say that without, maybe provoking some controversy here, I think are more the judges he's put on courts of appeals than, Brett Kavanaugh or Amy Coney Barrett. And we see that in the Fifth Circuit. The Fifth Circuit has 17 active judges, 6 of them are Trump appointees, right? I think 13 total are Republican appointees. And there's no administrative issue too small to not be a major question. This is a court of appeals that said that the Nuclear Regulatory Commission lacked the ability to create temporary licenses for the disposal of low-level radioactive waste because Congress hadn't specifically authorized the Nuclear Regulatory Commission to deal with radioactive waste. If not the Nuclear Regulatory Commission, then who? I guess maybe the Teenage Mutant Ninja Turtles, right? And so the problem is that you have a court of appeals that is willing to go much further than we've ever seen before. You have outlier district judges like Judge Kaczmarek in Amarillo, where you can also ensure that cases are heard by him by filing in Amarillo. There's 100% chance right now that if you file a new federal lawsuit in Amarillo, it gets assigned to Kaczmarek. And Devin, the result is basically government by injunction. And at the moment, right, that pain is being felt by the Biden administration. But, let's be frank. Especially for folks who have, political sensibilities that look more like mine, we're going to see the exact flip of this in a future Republican presidency, whether it's, lawsuits filed in single judge divisions in Eastern Washington state or in Vermont or in other parts of the country where you can have similar manipulation of dockets. And I just think that in the long run, Devin, that's unhealthy for government because, as Kate said, it's just a massive transfer of power from the democratically elected branches to unelected judges. And maybe we like some of those judges more than the others, but there's no coherent vision of the separation of powers in which we're better off in a world with unelected judges running the government. And yet that's where we're heading.
That is entirely fair. And you said there are 11 of the 55 cases, just some of the cases that we'll be talking about today: Jarkessi versus SEC versus Jarkessi, Murthy v. Missouri, Net Choice v. Texas, Cargill versus ATF, Alliance for Hippocratic Medicine versus FDA. And these are not small cases. Each and every single one of them is a blockbuster case in its own right.
Devin, I would just add one other thing. The other feature, they're blockbuster cases in the abstract, but one of the real nerdy reasons why at least 4 of them are blockbuster cases is because the Fifth Circuit's approach to Article 3 standing, that is to say, to who's allowed to be a plaintiff, is basically if we're sympathetic to you on the merits, you have standing, and otherwise you don't. That's a little unfair, but only a little. because the problem is that, last term we had 3 different cases where the Fifth Circuit was reversed for holding that a plaintiff had standing and the Supreme Court said it didn't. We're looking at least, I think, 2 or 3 of those this term. And the reason why standing is especially important in this context is because when the Fifth Circuit says, for example, that the Alliance for Hippocratic Medicine has standing to challenge the approval of mifepristone, or when 3 anti-vaccine activists and 2 red states have standing to challenge every single governmental communication with a social media company about COVID vaccine dis and misinformation, Devon, what that's doing is it's expanding the ambit of the courts. It's allowing courts to decide a broader range of issues than they otherwise would be able to. And so back to Kate's point about power grab, before you ever get to the substantive power grab that you see in the context of these, major questions doctrine, demise of Chevron, it's a power grab just to say we can decide these cases in the first place when, at least under long-standing interpretations of the Constitution, these are actually not disputes that are appropriately in the courts in the first place. If anything, that to me is the biggest theme undergirding the Fifth Circuit cases that are populating so much of the court's docket.
And I think that gives us a good transition point as we're talking about Judge Kaczmarek and all of the other fun judges scattered throughout the Fifth Circuit to talk about, in the wake of Dobbs, we've seen a mass amount of litigants move to Texas. We've seen state legislatures create striking statutes that limit women's ability to have abortions, to have safe prenatal health care. And 2 of the big cases, Alliance for Hippocratic Medicine, come from Kaczmarek, who is virulently anti-abortion and has been. And I think there's still a number of cases that are being brought before him as we speak that are in their very nascent stages. But he struck down the right to medication abortion. Based on oral argument, it seemed like that might not win the day. But Professor Fredrickson, I was hoping you could talk to us a little bit about what your takeaway from that case before the Supreme Court was, and how, even given what's going on with the court, how Kaczmarek's ruling has really given a lot of speed to efforts throughout the country to do things with mifepristone, like Louisiana deciding to criminalize its possession last week.
Well, I think it's a great question, and obviously he's lit a fire under a lot of the anti-abortion activists to push on these extreme arguments, which are gravely consequential, not just for women pursuing a needed abortion, but also for people who want medicine that at some point a court might decide has not been appropriately regulated by the expert agencies. It puts us in an extraordinarily dangerous position to have these highly ideological judges deciding at which point something should not be accessible to somebody with a medical need who's gotten a prescription from their doctor. We can all imagine the different circumstances in which that might arise. And I did want to sort of react to something that Steve said. I'm entirely in agreement about sort of the manipulation of standing. But I guess I'm perhaps more cynical in the sense that I think the Supreme Court has completely opened the door to this. And as someone who's taught constitutional law at Georgetown, I have had an extraordinarily hard time with my 1L students, and maybe my fellow law professors feel the same way, but trying to explain what the hell goes on with standing doctrine. And it seems that the Supreme Court is just as guilty of choosing their plaintiffs, giving them standing, depending on whether they like the outcome that might ensue. But certainly we have a situation where women and others across the country are in a position of a great danger in very precarious situation because the medical attention that they might need is now in danger. I think as far as the Supreme Court goes, it sort of gives them what they might see as a welcome opportunity, similar to the Louisiana voting rights case, to kind of say they're not quite as bad as the Fifth Circuit. We're just a little bit better. Maybe they will cut it back. Maybe medical abortion will still be available, but it will not be available through mail. delivery, but in the doctor's office, which will put us back to prior to the pandemic, despite the fact that medication abortion is extraordinarily safe and easily administered by women themselves at home. It will put us back, and by that they will show that they are somehow moderate and try and mitigate all of the damage that has been done by upside down flags and very luxurious minibus, or not minibus, maximum bus trips into, I guess, Walmart parking lots. But all of that, now they will be able to show themselves as somehow not so bad, because they're better than the Fifth Circuit after all.
Well, I don't know that that's saying much, especially when on the other side of that coin, you have the EMTALA cases in Idaho, in Texas, that are spreading. Kate, could you talk about those a little bit? Because I think those are slightly diametrically opposed to what's going to happen with Alliance.
Sure. And I should say, I do think that as to Alliance, the court is likely to find that these physicians don't have standing, and thus that would leave medication abortion available on the same terms that it is now, because the court has a stay in effect. And so the really extreme ruling of the district court and the less extreme but still quite extreme ruling of the Fifth Circuit actually haven't gone into effect to this day. And I imagine the court, or at least the way I read the oral argument, the court is going to find that there was never standing, the physicians in the case did not have standing, and thus the medication abortion would remain available. Now, the district court judge that Steve referenced, Kaz Merrick, has permitted the intervention of several state plaintiffs. So I imagine the same challenge that is before the court now will, in a year or two, be back before the court, if I'm right about what's going to happen with this case. And so medication abortion may be secure only in the very near term, even on an identical theory as the one that the court is considering on the merits now. So that's I think my short-term prediction about the mifepristone case. But I do think that I'm not sure, honestly. I had a difficult time reading the oral argument in the EMTALA case, but that's a case that involves, just briefly, a clash between a federal law that requires hospitals that accept federal funds to provide stabilizing care to patients who present at emergency rooms in crisis. That includes pregnant patients for whom very occasionally, but not never, the appropriate stabilizing care is the termination of a pregnancy, typically when someone is having a miscarriage anyway, but where an abortion is the prescribed standard of care to keep the patient, safe and healthy and alive. And Idaho, under its post-obs abortion prohibition, differs from federal law in a significant way, which is that it allows the provision of abortion only in the last of those circumstances that I just described were necessary to save the life of a patient. And so there is a gap between what the federal law requires hospitals to provide and what Idaho law provides hospitals to. Requires hospitals rather to provide. And under ordinary preemption principles, the federal law should control, and the federal statute should permit doctors to give life and health preserving care to patients in crisis. And yet I don't know that was the likely outcome in the case coming out of the oral argument. I was a little bit less pessimistic, I think, than some court watchers. I thought there was a real open question about where Justice Barrett and Justice Kavanaugh, I would say, were about the case. So if those two joined the Democratic appointees, it's possible that the federal law, actually would control. And it's also possible that they might try to read the Idaho statute as essentially permitting the same scope of care as the federal law requires hospitals provide when doctors wish to provide it. And that might, in the short term, mean that, pregnant patients in crisis do get, necessary medical care in the state of Idaho, although I think involves some pretty tortured statutory interpretation to get there. So I'm not sure, but I do think that many people, and they're probably right, I sometimes am unduly optimistic about the, likely future decisions of the court. But I think that it's very possible that the court will simply say that regardless of this federal law, I'm not sure how the decision would be reasoned, like in a way that squares with preemption principles, but that this federal law actually does not control, and that Idaho may prohibit care in a situation, and the Idaho lawyer before the court conceded that this situation might exist, where a patient is in crisis, and organ loss is a possibility, but death is not at least an imminent possibility, and Idaho law under those circumstances would not permit abortion to be performed upon a patient. And that could well be what the court says is the best reading of these two conflicting bodies of law. So that I think is where we might be headed.
That is incredibly disturbing, and I never thought that I would have to wish upon a star for the Supreme Court to uphold the supremacy clause of federal laws over state laws. But that's where we've landed. I want to transition just briefly back to another fun Fifth Circuit case. Well, two Fifth Circuit cases specifically, Murphy v. Missouri and the net choice cases, because to put it bluntly, this Fifth Circuit seems to be talking out of both sides of its mouth. In this case, in Murphy, they said the government is not allowed to talk to, the federal government is not allowed to talk to social media companies in any regard. It doesn't matter if it is massive misinformation, national security, what have you, no talking. In the net choice cases, they say Texas gets to control all content moderation for social media companies. And I don't know, Steve, can you square the circle for us as to what's going on and what you think the court might do in these cases?
Yeah, I mean, I think both of these cases have at their core, conservative complaints about the relationship between government and social media. And so, in the Murphy case, the complaint is that the Biden administration was jawboning social media companies when it came to suppressing vaccine-related mis and disinformation, right? In net choice, the complaint is that Texas should be allowed, right? And Florida should be allowed to coerce social media companies into content moderation. So basically, government should be able to regulate and coerce social media companies when we like the government, but not when we don't. That seems to be the through line for both cases. Devin, the irony to me is I actually think that one of the real challenges of this term, and maybe this is where Caroline's going to be a little more cynical again, is when, and I say when, not if, the Supreme Court reverses at least many of these Fifth Circuit decisions, as it already has in the CFPB funding case. I think there are going to be a lot of folks who are inclined to defend the court who say, look, right, the court's not nearly as problematic. It's not nearly as extreme as people like this Vladeck guy make it out to be. When the reality is that the lower court decisions that provoked the Supreme Court's involvement in these cases were themselves quite extreme. And so it says, I think, a lot more about the lower courts. I mean, one of the things that Murphy and the net choice cases have in common is in both cases, the Fifth Circuit issued or didn't issue forms of emergency relief, forcing the Supreme Court to step in. So in both cases, we already have a pretty strong clue of what the Supreme Court thinks, because in the net choice case, it put the Texas law back on hold after the Fifth Circuit had allowed it to go into effect. In the Murphy case, it froze the district court's injunction after the Fifth Circuit had only narrowed it. And so, Devin, I think the reality is that, as was true last term with the Section 230 cases, the Supreme Court, I think, is not where the sort of heart of the current Republican Party is when it comes to the relationship between government and social media. That there's more of a establishment conservative vibe when it comes to these kinds of cases, which means a court that's going to be skeptical of the jawboning arguments and maybe just resolve that on standing, which means a court that's going to be skeptical of a state's ability to force a social media company to moderate content. I could see maybe a narrow decision in one of the net choice cases relying upon the dispute being a facial challenge as opposed to an as-applied challenge. But I think the reality is when the term is over, we're going to look at these cases, or at least some people are going to hold up these cases as examples of the court being responsible. And I think it's worth putting in context, like, yes, it could always be worse, right? But sort of reversing the Fifth Circuit for basically trying to have its cake and eat it too, I think, is not necessarily something for which the justices will deserve a participation trophy.
I wholeheartedly agree, because them not doing the worst thing possible is not a gold star, because so often, even when they have the chance to just smack down the Fifth Circuit and say, bad Fifth Circuit, bad Fifth Circuit, they leave the door open for future malfeasance in some way, shape, or form, and the Fifth Circuit just keeps kicking that door back down. I've been saying for a minute that we're all frogs in a pot and the Supreme Court is just turning up the heat slowly but surely. The fact that they don't turn it up to full blast immediately is not a cause for celebration. Which I think, as we're running out of time, brings us to the next thing. So we're not completely doom and gloom about all of this, is the fact that they are ostensibly a co-equal branch of government to Congress and the presidency. And one of the things that I think we need to all recognize, and you all have certainly, is that Congress should be asserting its authority more forcefully by means of reforming, perchance structurally, the Supreme Court, and certainly the laws and standards by which the court by which agencies are able to operate to prevent this type of judicial malfeasance and overreach that we're seeing. And Caroline, can we jump to you first for your thoughts on how can Congress respond in a robust manner to this court?
Absolutely. And I think it must and it needs to. I mean, there's obviously the need for hearings, which is sort of, low-hanging fruit for the moment at least. And the Democrats still control the Senate and the Judiciary Committee, and it should be a place where they have a real discussion, and whether or not the justices voluntarily come to testify, they can still talk about these issues. I think that's an obvious thing that if they don't do, that's talk about malpractice. Beyond that, though, there are a lot of areas, some of which we've touched upon, and one of which was discussed right at the very opening. Term limits for justices are something that are widely approved of by the American public across the political spectrum. We are so out of step with almost every country in the world with a court system with an apex court that has lifelong ability to stay on the court. Almost every single one has either a retirement age or a set number of years. And with the coupling of something that I was thinking about that Steve said on the podcast that he was on, I was listening to earlier today with Dolly and Lithwick, was about, and I think about this a lot because I write about French court system, but the uniqueness of an American system where we have an apex court that is both the final word on constitutional questions and also the highest appeals court on statutory matters. You couple that extraordinary sweeping jurisdiction with lifelong court membership with the fact that they can, impeachment is not an option. It doesn't work in their system. It's no Supreme Court justice has successfully been impeached, nor has any president, meaning convicted by a Senate. And as a result, the kind of impunity which is given to them to sit on the court for now upwards of 30 years for a number of them, and to be able to exercise this extraordinary power and having the last word on what are some of the most fundamental rights and freedoms that Americans thought they should enjoy, puts us in a place that I think is extraordinarily dangerous for a democracy. So that's an obvious one. There are proposals that I think can be done statutorily. I sat on a working group of the American Academy of Arts and Sciences, again, a kind of cross-partisan group of scholars that agreed that there is a statutory way in which this can be accomplished. I could go on, but I see, Devon, you probably want to move on to some of the other reforms, but I could speak about court expansion, which at this moment, it's not something I normally would have supported. But at this moment, I think this particular court is so out of bounds that I would actually advocate. And that is obviously Congress can do.
Fair. Well, yeah, we're running out of time. I just want to remind the folks who are watching this that if you want to submit a question, now is the time. We've got about 10 minutes left, but I definitely don't want to turn away from thoughts on reform before we get to audience questions. So, Kate, I'll jump to you real quick.
Sure. Yeah, I'll try to be brief because I do want to leave time for questions. I think that short-term hearings are important. And I also think that, Steve, I think you write about this in your book, although I jump in if I'm wrong about this. But after Bush v. Gore, when there was a lot of interest in the Supreme Court, right, I think it wasn't a particular hearing convened for the purpose of grilling the justices about Bush v. Gore, but just one of these, routine budgetary hearings that was it Thomas and Kennedy? Was that what? Anyway, yeah. So this is all just cribbed completely from Steve's book. But they were sharply pressed on Bush versus Gore in a way that I don't think we've heard them pressed in the halls of Congress in the quarter century since. And I think that would be very healthy and constructive. So that's something they could do when they have their, the routine invitation to come up to the Hill to talk about the court's budget. They could ask them about ethics. They could ask them about recusal. They could ask them about good behavior. They're the ones posing the questions, and the justices are there and have to respond. And so I think that would be very, very constructive and healthy. And I do think we should be having more robust conversations about things like expansion, which, has, early in the Biden presidency, there was talk about. There has been very little talk about it in recent months. And I think that should be much more on the table. And I think that, the president and surrogates for the White House should be spending a lot more time talking about the court, both as a democracy issue and as an election issue in a much more sustained way than they are right now.
I just want to put in a really quick pitch for making the court busier. Right, that this is going to sound odd that someone like me would want the Supreme Court to do more, but actually it turns out that the Supreme Court for the 5th term in a row is going to be deciding fewer cases than it has since the Civil War. Right, that the court hadn't fallen below 60 cases between 1864 and 2019. It's going to fall below 60 again this term. The point is not that, yes, we want the court causing more mischief in more areas of American law. The point is that the Congress over the years has given the court too much control over its docket. And that I think one of the things we're seeing, not just in the cases the court is hearing, but in the behavior of the justices more generally, is the consequences of Congress taking its hands off the court entirely. We may never have the political ability to pursue the kind of really, really big structural reforms that I know a lot of the folks on this call would prefer. But there are some pretty low-hanging fruit reforms that I think would go a long way toward reasserting even a modicum of congressional interest and involvement in regulating the day-to-day operations of the court that I think we ought to be talking a lot more about. And docket reform, nerdy though it may be, ought to be close to the top of that list.
No, that is amazing. Thank you all so much for your time. I'm turning to questions, and I think that is an interesting take. And I want to go back to one of the things that we were talking about earlier, in the way that a change in administration could affect things, the way the lower courts rule, the way the Supreme Court rules. I wanted to get your thoughts, Caroline, about how the judiciary could change in the case of a GOP trifecta in 2025, but also how what the court is doing right now is also maybe laying the groundwork a little bit for the Project 2025 agenda.
So I must admit, I am in the south of France now. So the scenario that you described is the one that will mean that I'm going to stay here. But so I think it's extraordinarily worrisome. And I think we've seen indications already about the direction, the idea that somehow some of the judges that Trump appointed in a first term, which I hope will be an only term, were not sufficiently adherent to the ideological vision of Leonard Leo, et cetera. And some idea that they need to be more rigorous even in controlling the kinds of appointees. And that is very much in line with this 2025 project that you mentioned that's being run, I believe, out of the Heritage Foundation, where they're trying to make sure that the judges are a lot more like Judge Kaczmarek, Judge Ho of the Fifth Circuit, et cetera, and don't have any deviation from that a particular model, which is really unconstrained by any particular judicial philosophy or jurisprudential methodology, but really addicted to certain kinds of outcomes, however they may get there. And I think that seems to be what we are going to see. If there is a trifecta, those judges are going to be served up by Leonard Leo and his cohort. They're going to be nominated by Trump. They're going to be quickly confirmed by a Senate, and the House will do whatever they need to do to make sure that the wheels are turning to fund the programs they like and to make sure the ones that they don't are eliminated. I think we can see, perhaps there'll be some difference in some of the minutia around how they understand unitary executive theory or other kinds of approaches that might be modified, or strengthened, depending on the orientation, really between by who's in power. I think all these doctrines, the major questions doctrine, non-delegation, unitary executive, are really convenient as a way of covering up, getting you the outcome that you want.
Thanks. One of the areas that we didn't get to, just because this has been such a jam-packed Supreme Court year, that our audience wants to inquire about is thoughts around Rahimi and Cargill, because they could have such broad Second Amendment implications. And I'll just toss that out for whoever wants to take a stab at it. I won't say take a shot at it because that would be too punny.
I'll just say take one beat on it on the two. Yeah, I mean, I think Rahimi really is sort of the test case in terms of how far how committed the court really is to the really extreme vision of the Second Amendment that the Bruin case sets forth, which is, you have to look to historical gun regulations in order to successfully defend contemporary gun regulations, which I think means, the demise of any sort of genuinely innovative and in lots of ways genuinely effective, meaningful gun safety regulation at the state, federal, or local level. I think probably the court is unwilling to go as far as siding with Rahimi and invalidating this domestic violence disarmament or disarming provision for individuals subject to domestic violence orders of protection. So probably some version of the Bruin test gets rolled back in some form in Rahimi. And I think that is good news with respect to this federal law and other federal laws that continue to restrict access to guns. I don't know how intellectually honest an opinion will be. I suspect not very much, not very. Cargill, I think, is more of an administrative law case. There is sort of an embedded Second Amendment issue that Kavanaugh was kind of pressing at the oral argument about, but it really is about the power of federal agencies, as so many cases on the court's docket are. And I truly don't know. That one felt like a coin toss from the oral argument.
I'm sorry, Steve. Do you want to
just really quickly? I mean, the case, right? Rahimi. The thing about Rahimi is that it is such an easy case for the court to reverse without getting into the really hard question, which is just how many federal gun laws are going to fall under Bruin, because the Fifth Circuit picked just about the easiest one to defend, to strike down. And so the real issue is going to be next term, when the court gets one or a series of cases about the felon in possession statute, which is a much bigger deal, affects a lot more people, and is going to, I think, be far more likely to fracture what's likely to be a 6, 7, or even 8 justice majority in Rahimi. So, Devon, it's kind of weird because here it is, May 29th, and the court has a grand total of 9 cases on its docket for next term. That is insanely low. Even last year, when we were talking about historically low numbers of grants for the upcoming term, the court had granted, I think it was 16 cases by the end of May, right? 9, I think, is less than 16, last I checked. And so, the sort of what the court is not going to be done when it rises for its summer recess. It's going to have a lot of other big stuff coming. And I think Rahimi is probably more a harbinger than it is a major case unto itself.
Well,
and Devon, if I could just jump one quick little thing, just to say, I think the Bruin case and Rahimi now are a perfect evidence of how political this court is and how driven by outcomes, because there could not be a more manipulable doctrine than history and tradition. And simply, Rahimi allows them the possibility of, I think, maintaining Bruin pretty much as a whole, but simply it depends on what level of specificity you look at in terms of what the applicable gun law was at the time. They can find something that they can say is analogous enough and keep Bruin in place, and then they'll treat it differently, as Steve says, in felon in possession case come before them, and be much more rigorous in terms of specificity. But let's just say it depends on where they want to end up.
I mean, if we're looking back that far, we can say that felonies resulted in civil deaths. So it would seem that there would be something kind of analogous back then. But if we're bringing civil death back up, then that's a whole other issue that we're going to have to deal with. I have so many more questions for you all. I wish we had another hour. Unfortunately, we don't. You're all incredibly busy people, and I truly appreciate you spending an hour of your day and a lot of time preparing for this conversation. Professor Steve Vladeck, University of Texas School of Law, Kate Shaw, University of Pennsylvania, Carey Law School, and Caroline Fredrickson, the Brennan Center for Justice. Thank you all so much. We very much appreciated you. And we very much appreciate everybody who tuned in to watch us today. Thanks, everybody. Take care.
Thanks, Devin.
All right. Thanks, Steve.